5 minutes for rebuttal unless you tell me something to the contrary. So with that, we'll start with Bloom versus Nussbaum. Mr. Damodar.
Yes, Your Honor. Tom Damodar, representing the plaintiff, Susie, and appellant, Robert Bloom. We're here on various issues we brought before the court. This was a summary judgment that was granted by the court. Judge Cisco. The final judgment itself was entered by Judge Isom. We sued for breach of contract, fraudulent inducement, unauthorized use of the name under Section 540.08, Code of Statutes, and unjust enrichment. We had various discovery problems. The defense wouldn't permit depositions of their employees and officers. We had to fight for that for more than a year to get that done. The last of which was held Friday before the April 8th hearing on the motion for summary judgment, which was just set for half an hour, and all we did there was hand the judge what we had, advising her that we have yet to have the depositions from the Friday before transcribed. Defendants didn't waive reading and signing, so they have another 30 days to read and sign. Judge Cisco gave until May 8th to file those documents and some type of a summary on those documents. I did a response, and then the defense went and struck it because they said, well, first of all, when I went to file some of the documents, there was a problem with e-filing, and I did it like at 1 o'clock. Finally finished about 1 o'clock in the morning on the 9th. But before that time, discovery cutoff was April 8th. And we get to the hearing on April 8th, and then it gets changed to nothing can be filed now after this hearing at 8:30 in the morning. Well, that just cut short a whole day. I had a declaration of my client was still working on, and we filed it that day, and the judge struck that.
When was the motion for summary judgment actually filed? How long had it been pending at that point in time? I don't really know.
The defendant's motion for summary judgment was filed back in 2012, because it was originally set for October 8th, 2012 for a hearing, which ended up being a case management conference because we didn't have discovery. They wouldn't permit discovery.
And when were you supposed to have things filed in opposition to summary judgment?
Well, before that hearing, the first hearing on their summary judgment, we couldn't file anything because we didn't have anything. There was no discovery. Again, we tried and tried and tried to set depositions, and then they just resisted. So the order was motion to compel depositions and discovery was granted at that hearing, and we did a lot of depositions for the rest of the year through December, and then we didn't finish, and came January trying to set depositions. I think we got a couple more, Dr. Nussbaum and someone else at Synergy, but we still didn't finish. We didn't get the rest of them. Denise Ricks was one of them. Denise Ricks worked for both defendants, all defendants, and she moved to Texas, and I was instructed to contact her through counsel, Mr. Brennan, Dr. Nussbaum's counsel, to schedule depositions. Well, it never happened. So I started searching for her myself. I sent letters. She didn't respond. Finally, we got it settled, scheduled, because the court ordered it. February 4th says, get these depositions done. And trying to schedule them, it get pushed all the way back to April 5th. Whether that was a ploy on defense counsel's part or just by circumstance. I mean, they had ski vacations, family things to do, whatever. And so April 5th was the date. I filed a motion to continue the April 8th hearing because the fact that these depositions aren't going to be before the court. I need time to read them. Denise Ricks was important. That's why I amended my plaintiff's motion for summary judgment and motion for sanctions, because I needed her testimony. Because all the affidavits the summary judgments were based on were false. Whether it be IPCs, they had 2 affidavits, they were false. And Nussbaum and Synergies, their affidavits were false. I mean, false in the sense of extreme falsity. When you sign an affidavit and saying that Dr. Bloom appeared face-to-face and talked to you in the office of Synergy, and Synergy didn't have an office, that's extremely false. Synergy was, there was a deposition I filed in a previous case, Dr. Nash sued Dr. Nussbaum, February 2009, before my client even met Dr. Nussbaum. And at that time, he testified that they went to a virtual office. His office manager, Easterix, moved to Baton Rouge, and she ran things from there. And my client is the one who he communicated with her to get all the paperwork in, get the contract sent to her and everything like that. And so there was no office. There was never any face-to-face. The only face-to-face was between Dr. Bloom and Dr. Nussbaum when he came down to interview. And that's when he was told that there's going to be, we're trying to sell the company, and apparently he already had an agreement because they were real close, because the IPC, Marcy Matthews, testified that many months before they actually signed this agreement in July, they were negotiating. So he knew it was coming down closer to get finalized, and he told them that we're going to have...
Tell me what your legal theory is against Inpatient Consultants of Florida that wasn't right for summary judgment, or why the summary judgment as to that defendant is in there.
The court not only misconstrued the facts, but the asset purchase agreement between Nussbaum and IPC, and I want to make it clear, it's between Nussbaum and IPC. There was a typo in my brief on page 35, the first paragraph. There was a Synergy assigned all the assets of Synergy to Dr. Nussbaum personally, and then he's the one that sold them to IPC. But the contract, the asset purchase agreement, specifically provides that he cannot terminate any physician contract, which is Dr. Bloom, because if they weren't hired by IPC, they wanted to be able to enforce the non-compete. And there is a non-compete.
But doesn't the contract provide for a 90-day termination without any cause whatsoever?
It does, and that never occurred, because if you look at all the termination agreements that were sent out by Synergy, by Dr. Nussbaum, he didn't send one to Dr. Bloom. He sent to all the other physicians.
Did the appellee, or one of the appellees, Synergy, send a notice of termination to your client?
No. They said that they sent a letter on August 5th, but they didn't send it to the right address, or they didn't. It was never received by my client. Even though they emailed.
What evidence of record is there that your client didn't receive it?
Yes, there is record.
What record evidence is there that your client didn't receive it?
The deposition of Attorney Leslie Barnett. It was sent from his office and came back to him.
And he said he didn't send it to the right address. He said, tell me what he said.
No, he had the envelope in his hand.
Okay.
It was returned to him.
And was there anything wrong about the address? Was it certified and unaccepted? Did your client file an affidavit saying he didn't have notice?
My recollection is it was sent to the new address of my client in Plant City, but he was not physically there to accept it because he was still in the process of...
Was it sent to the address that was provided for in the contract? Was there any evidence?
I don't know if there was what address was on the contract. I don't remember, but I can.
Well, the question for me to you is,
okay,
what evidence is there that the termination notice was not properly sent in the time frame provided for in the contract to the location provided for in the contract?
The August 5th letter not received by my client talks about Dr. Nussbaum is not going to sign the contract. Remember, he's the one that tendered the contract to my client. My client signed it, sent it back. It's a contract. He later testified he was employed from that date. So, but this letter that was mailed out from Attorney Barnett's office said that Dr. Nussbaum is not going to sign the agreement. But a letter sent the same day by email to my client says that IPC, you're going to be having a continued employment with IPC, and that's what was happening. So I don't know why they didn't send email both ways, both letters, but despite that fact, there's also the termination agreement that they sent to all the other physicians that they were terminating because they're getting hired by IPC, and they never sent one of those to my client at all. So why wouldn't they send something? They treated him differently. They didn't invite him to the get-together in July when they all got together and met the directors of the local IPC office.
But there was an affidavit by IPC that your client refused or failed to execute documents, questionnaires, applications, I don't remember what the term was, but that he didn't proceed as he needed to pursue employment with IPC.
That was in August 2009. They said he didn't sign his disclosure and acknowledgement form to enable them to do a background check on him. Yet in emails in June of 2009, they're all talking about his background there. Because the credentialing package that was sent by Denise Ricks of Synergy to IPC was obviously received by IPC because they're talking about everything that's in there. All his credentialing, all his information he already disclosed. Hospitals had already approved him, waiting for him to start. Then IPC said, well, we don't have that credentialing
There are
package.
affidavits by IPC or on behalf of IPC that refer to domestic violence issues, I think some Medicare or some sort of fraud issues with other practices that your client was associated with. Here they seem to dredge up a number of issues relating to why your client was not immediately offered a position, and then they talk about the fact that your client didn't provide information in order to secure the position. What is there of record that establishes your client's right to go forward with IPC, notwithstanding what IPC filed?
Because Tim Larry, who was the vice president of IPC, said his only red flag was the fact that my client had yet to get his medical license, because it was going through the process, and he didn't receive that until August. But even after he received it in August, they still wouldn't talk to him. They wouldn't let him turn any papers in. They wouldn't meet with him. They're all pointing the fingers at each other. We're not going to do it. You do it. And then Dr. Nussbaum tells Mr. Geens of IPC that he doesn't want to be responsible for all the moving expenses that Dr. Bloom had. So he didn't want to have anything to do with him being hired. He didn't need him anymore because he already got the $2.5 million because he had enough people that signed up with IPC.
And he had a contractual right to terminate your client with 90 days notice.
And that was never done, correct. But he never gave the 90-day termination period. And it's also admitted that if he did give the 90-day termination period, notice that my client would be entitled to 90 days of compensation. That was never done either. It's admitted they didn't give him a penny. But that contract, the Synergy Physicians Agreement is non-severable. The law says it's non-severable. IPC picked up the contract they picked up the non-compete agreement, part of it. That's why they were included in the breach of contract. If they picked up the non-compete, which my client honored by working elsewhere in Florida, not in the Tampa Bay area, they have law obligations of paying and compensating for that non-compete. Because under the law, you can't have a non-compete without an employment agreement or some kind of contractual relationship that allows you to do that.
So your position is that if the contract was terminated, the covenant not to compete also has to be terminated?
Right. When the contract is terminated, that termination agreement...
Doesn't that fly in the face of everything in Florida law, that covenants not to compete are designed to survive termination of agreements?
That's between employer and employee. That's where there's compensation given to have that non-compete. There was no compensation given here. And that's what the error is. My client's still entitled to compensation. If the court should find
Did your client file an action seeking to declare the covenant not to compete invalid as to IPC?
No. We didn't file suit to declare that invalid.
So potentially your client could have competed and then taken the chance that it might have been unenforceable as to him, or it might have been enforceable.
Well, he didn't take that risk. He just honored it and went to Central Florida and worked over there, which happened to end up working for IPC's subcontractor over there, tending to IPC patients. He got approved, got it on their computer, and so any red flags, like Mr. Larry was worried about, Mr. Red Flag was only the fact he didn't have his license. He finally got his license. But back to Judge Alderman, I know I didn't finish that question, but the termination, IPC, again, picked up that by assignment because it specifically says in the asset purchase agreement, Synergy cannot terminate any agreement for any physician that does not have a contract with IPC. So again, Judge Silverman, back to your position about the covenant not to compete continues after termination of a contract. The thing is, the termination, the not-compete ended up with a new contract, so they got consideration there. And they got a new contract that has its own non-compete with IPC. Dr. Bloom never got compensated for the original non-compete.
But your client never actually went to work for Nussbaum or Synergy, never really reported a day. I believe the record shows that he just never went to work, period. And I had understood from your brief that you took the position that, that the licensure was the issue. That's why I never reported to Synergy or Nussbaum. But you took the position that the contract said he could have done things such as managerial and administrative duties, and he could have, but they were never assigned to him. Is there anything in the record that would suggest that he has any of this background or expertise, managerial or administrative? I mean, he's a physician.
In private practice, he was a physician in private practice, had his own place up there in Alabama. He managed this
background in these other things that you said he could have been assigned to? Does there records show that he has any experience in administrative or managerial?
He managed a zoo up there, a private zoo, which was being moved down here also. That's in the record. And he had to give up all his practice up there, which caused him financial difficulty. He lost his house because he was promised to go to IPC, promised continued employment. That's all in the letters. It's all in the agreement. That's all been represented to him, continued employment with IPC, and it never occurred.
I mean, he was very clearly hired for his expertise as a physician. It appears that's the whole reason he and Nussbaum and Synergy had these initial, efforts for him to come to work there. It doesn't, from the record that I read, there was no effort, there was no discussion that he'd be a manager or an administrator, and there was no record information that I saw that Nussbaum or Synergy had an opening in that part of their operation. Do I understand that correctly?
Well, I don't know what their need, if they had a need or not. They didn't have an office, but again, the other person worked out of her house in Louisiana, in Baton Rouge. But the fact is, he was an employee since May 6, 2009. That is admitted now by Dr. Nussbaum. At first he didn't, because he said, no, he didn't have any permission to use his name on the letterhead and the contract.
What's tough about this case is sometimes he is an employee.
We're running into rebuttal time here, so.
Okay. All right, thank you.
All right.
How are you going to split your time, or are you going to split your time?
10 minutes? You need 5? Evenly, Judge.
I'm sorry?
Evenly, we'll split the time.
Okay.
Although, 5 minutes for IPC's counsel, Judge.
Okay.
I think her argument's a lot simpler. May it please the Court, Edward Brennan on behalf of Synergy and Dr. Nussbaum. I was confused when I initially got appellant's brief in this case. I'm even more confused now. But I think Your Honors have hit the nail on the head when you've asked the specific questions. What is in the record to support any of Dr. Bloom's claims? And quite frankly, there's nothing in the record.
Let me ask you this. The physician's agreement, which is dated May 6th, I'm assuming became effective roughly August 4th.
Became effective August 4th. He was terminated August 5th.
And tell me how he was terminated.
There were 2 letters sent to him, one by a certified mail from Les Barnett, one by a mail from my client directly to him at his, I believe, his Plant City address.
Okay. And is there, in fact, a deposition where Les Barnett says it came back to me?
Yes, that's part of Les's deposition. That
Okay,
he
so
says,
what is the evidence that a notice of termination was delivered to this doctor?
Dr. Bloom's deposition, page 44, indicates that he received notice of termination and then began to seek his new employment with Synergy. That's exactly consistent with what happened. He was advised he was terminated, and he began the process immediately to become employed by Synergy.
The termination that I guess everybody got so that they could re-employ with the new group. Is that right?
Absolutely correct, Judge. Everyone had to be
So I
terminated.
guess what's confusing me a little bit is this is a $170,000 a year contract that began on August 4th for payments to be made twice a month, and I don't understand why he's at least not entitled to a penny in this process.
Judge, I can tell you why he's not entitled to a penny. One, he's never done one single item of work for Synergy. He never worked in any capacity. Never his deposition.
Well, was he asked to?
Well, no, he wasn't asked to, but he couldn't.
Does the contract require him to work?
Contract does not require him to work.
So why isn't he owed at least a penny?
Well, Judge, the contract says for $170,000 a year for services rendered by doctor.
But how did he breach this contract? I mean, is your claim he breached this contract?
I'm not saying at all he breached the contract. As a matter of fact, Judge, I'm suggesting there is no breach of this contract whatsoever. The contract.
So why doesn't he get paid for 90 days?
Why should he, Judge? There's no basis in the contract.
The contract says that he gets paid $170 grand without necessarily having to do anything, and it has a 90-day cancellation period, which you invoked about the same day that the contract became effective. So,
Judge, the $170,000 is clearly spelled out in the agreement that it's for work performed. Page 1, subsection 3.3. Synergy shall pay doctor a minimum salary of $170,000 per year for services rendered by the doctor. Now,
well, what services did you ever ask him to render?
He could not render any services until he became credentialed. The agreement never became. But
your agreement starts without regard to whether he's credentialed. It's 90 days from the signature or when privileges are granted.
Right.
There's no condition that he be licensed before this thing kicks in. Is there?
Well, in order to be credentialed, you must be licensed.
Right.
Right, and that's in the record.
And so since you allowed it to start from 90 days of signature without regard to whether he was credentialed, you knew there was a risk with this fellow that he's not going to be able to perform services as a doctor on the 91st day, even though he'll...
Well, there was no risk associated with the doctor on the 91st day. We hired with the doctor with the good intent that he was actually going to be able to become credentialed and or become viable to the company within 90 days or being credentialed, whichever came first. The idea being...
Is the agreement void or ineffective if he's not a licensed physician in Florida on the 90th or 91st day?
No.
So explain to me again why he doesn't get that first paycheck.
Along these lines, one of the difficulties I have is that you do take these inconsistent positions about whether he's an employee or not. And as I want to give you a chance to help me with that, so let me get my question out and you clear it up for me, because I understand that, at least I think I understand, that you take the position that he's not owed any wages because he never became an employee. He never became credentialed, so life was never breathed into the agreement. On the other hand, you say he was an employee, so you had a right to use his name in the letterhead, which, of course, your opponent's position is what helped you strike the deal with IPC. So help me understand this. Is he or was he not an employee?
As of May 6, 2009, Dr. Bloom became an employee. However, the contractual terms by which he would be paid, which he would be under obligation to perform things, would not take place until the effective date as set forth in the contract. For example, Dr. Bloom was living in Alabama. He was not licensed in Florida to practice medicine. What good is he on May 6th to Synergy, who only has a practice in Florida as a medical doctor?
Was the contract fully executed May 6th?
Yes, sir.
Okay.
Even though it's not...
The agreement says it's effective 90 days from date of signature or when privileges are granted, whichever is first. So
Correct.
90 days would roughly be August 6th, August 5th.
It's August 4th.
Somewhere in there. What's that?
August 4th, the day before we terminate.
August 4th. And the notice of termination
August
is
5th.
August 5th. That kicks in a 90-day termination period.
90-day termination period if he's fired without cause.
Right. Well, was he fired with cause or without cause?
Interesting. If you look at the terms of the unambiguous contract, which is page 4, or excuse me.
What did the notice of termination say?
The notice of
Did
termination
it say
says,
he's terminated with cause?
The notice of termination says you are fired. Synergy has bought our assets. You are fired.
So there's no notice of termination with cause.
There is no notice saying you are terminated for cause.
Can that notice be read any way other than we are invoking our right to terminate you without cause?
Certainly. It's ambiguous as to whether it's for cause or without cause.
So what evidence did your client present in seeking summary judgment as to whether it was with or without cause?
I didn't present any evidence whatsoever.
So why would we not be able to read that it was a termination without cause, giving him a 90-day entitlement to pay, assuming it otherwise falls within the contract?
First off, there is no 90-day requirement for pay. This is a notice provision.
This agreement is effective 90 days from the date of the signature.
Correct.
Which you've acknowledged would be roughly August 4th.
Correct.
He is then given 90 days notice of termination, which to my understanding means that absent some other factor, he is entitled to get compensated for 90 days.
It does not say that in this contract, Judge, nor is it implied in the contract.
Tell me again where it excludes that.
It doesn't exclude it, Judge, but it doesn't
Synergy
say.
shall pay doctor a minimum salary of $170,000 per year for services rendered, and I think you're referring to the services rendered. Does it define what services are to be rendered to trigger payment?
It does not define what services are to be rendered. However, for a for-cause termination, if the doctor is not practicing the act, is not engaged.
So what evidence is there that it was a termination for cause?
Judge, there is no evidence.
So we're back to termination without cause, which support, at least for purposes of summary judgment, you haven't eliminated that issue, have you?
Judge, whether it's for cause, whether it's not for cause, there is no provision in the contract that states.
So you're giving me a red herring as to whether it's with cause or without cause?
I'm not giving you a red herring at all. I wouldn't.
Well,
presume to
you're
do
going back and forth, and you're trying to say it's with cause so he doesn't get paid.
What I'm suggesting, Judge.
But there's no evidence that it's with cause.
What I'm suggesting.
So we're back to without cause.
No.
So if it's termination without cause, why doesn't he get paid for 90 days?
Because there is no provision in the contract which states that if you're terminated with cause or without cause, you're entitled to any payment. Period. It doesn't say if you
Where
are.
does it say that if you're terminated for any reason, your payment stops at the date of termination as opposed to the 90 days?
It doesn't say either way, Judge.
So how do you win on that issue on summary judgment?
Well, Judge, it's a very difficult very difficult argument, and quite honestly,
I mean, you're making a great argument for the other side. I don't see how you're winning on summary judgment on that issue.
If Your Honor will note in my original pleading, I moved for partial summary judgment and did not ask for summary judgment on this particular issue. The judge.
So we should reverse.
I'm not confessing error. You don't hear those words coming out of my mouth. After reading Judge Hisco's very well-written opinion, I believe that she is absolutely correct when she finds that there's no obligation to pay him because he never worked. And after rereading the contract and the plain, unambiguous language of the contract, there has not been any services rendered, and he was terminated, and there's no provision in the contract.
What proof is there that your client presented that there were no services whatsoever rendered that would support payment?
Dr. Bloom's deposition, my client's affidavits, both of which say that Dr. Bloom never worked a day, never provided a service.
So allowing his name to be used is not providing any service to the corporation?
Absolutely.
Executing a covenant not to compete is not providing a benefit to the corporation?
Correct.
Okay. Do you have any authority for that?
I don't have any authority for that under the...
Can you think offhand of any case that has ever said that?
Well,
Because I can't.
It's certainly not goodwill that a...
So by his good nature, he gives your client an unpaid-for covenant not to compete.
Judge, he's bound by the four corners of the complaint. He had the four corners of the agreement. He had the agreement. He made changes to the agreement. He read the agreement, didn't seek out an attorney's help for the agreement, and he's bound by the agreement, no matter how unfair you may think it is, Judge.
Well, I think Judge
he's
Morris
bound by
or Judge Altenburn asked the question as far as, I'll read the provision of the agreement, doctor shall engage in the practice of medicine for synergy, performing such medical, managerial, and administrative duties as may be assigned to doctor by synergy. So what duties were assigned for him to perform?
None.
So he didn't have to do anything because he wasn't asked to do anything. So why is he not providing the service of his name and the covenant not to compete?
The contract is never effective until August 4th, Judge. It's a contract to begin work at some point in time in the future.
The contract is effective from August 4th until 90 days later. Do you agree with that?
No, I don't agree with that.
The notice of termination says he gets 90 days notice.
It does not say that, Judge. The
Okay.
contract, and Judge, if I may,
Synergy may terminate this agreement without cause upon 90 days written notice.
if you
What am
read,
I misunderstanding?
you're not misunderstanding anything. You're reading one provision of the agreement to your liking. If you read paragraph 5A of the agreement, it also states that he can be fired for cause when he's not practicing medicine.
For
Which he's not doing.
ceasing the active practice, but you never required him to actually commence the active.
Well, actually, Judge, he originally
I
practiced.
don't know what he was doing in Alabama, whether he was
Well,
practicing
he
there
was
or not.
practicing medicine in Alabama, that's also in the record.
Okay, so he hadn't ceased the practice of medicine.
He ceased the practice of medicine in Florida. He was originally in Florida as a licensed physician back in the 90s. He ceased the practice of medicine in Florida up until August 15th, 2009. So, in fact, it's under 5.A, as Judge Sisko found, even though I didn't ask for it.
So,
that-
I was going to follow up on that. You didn't move for a full and final summary judgment? And
I
you got,
did not.
and you got one.
I got one.
You know, don't question what you get, but that's kind of unusual, isn't it?
Well, Judge, and with you know, all candor to the court, you know, I spent a couple hours yesterday with my old law partner, Arnie Levine, trying to come up with a creative argument because I knew you'd ask me this very question.
Well, until you brought it up, I didn't understand this.
So it's it's not as crystal clear as I would like it to be, obviously. It is a provision that exists, 90 days. There's no provision for him to be paid. There's no provision for him not to be paid, with all candor.
Following up on that, are you entitled to a remedy you didn't ask for?
Oh, well, I think I could, well, I'm sure there is a remedy I could ask for, Judge, if this case proceeds. And I'm not sure what's going to happen with the matter. We'll address it as we go forward.
What was the basis of the motion for partial summary judgment?
All of the matters in the contract, other than the wage issue, which you've so all eloquently beat me up on this morning, all of the other matters in the other three counts, the unjust enrichment, the 540.08 unlawful use of Dr. Bloom's name, as well as the other count of fraud in the inducement. I think Judge Sisko clearly spelled out in all three of those instances why we're absolutely entitled to summary judgment.
So if we were to reverse, would you concede, understanding you don't concede it ought to be reversed at all, but if we decide that it should be reversed, is your position that it ought to be reversed to determine whether or not termination was properly accomplished and whether or not he's entitled to any compensation for the period, if he was properly terminated, the period from the time he was given notice of termination to when he was effectively terminated?
Without confessing error, Judge, if you were to reverse on any issue, I think that is the sole issue, and then whether or not he had an obligation to and refused to mitigate his damages. That's all. But everything else, I think Judge Sisko was absolutely spot on, especially in dealing with the IPC claim, which counsel can deal with herself. But that's the inherent weakness in the final judgment.
We're down to her time now, too, so.
Thank you, Judge. I appreciate the time.
Good morning. May it please the court, Denise Wheeler on behalf of Inpatient Consultants and IPC, the hospitalists, both of which I will refer to as IPC. For the past 5 years, my clients have asked me how is it that they are entangled in this litigation for a breach of contract claim when they expressly disavowed any contractual relationships with the healthcare providers of Synergy when they entered into that asset purchase agreement with Synergy.
When you did the asset purchase, did you purchase anything that would have tied you to this physician?
No, Your Honor. And there is no record evidence of us purchasing anything.
Would you have purchased their contracts with their doctors? Is that part of the assets or not?
No. And the assets listed expressly did not include any of
Because the contemplation was that they would terminate all their employees and you'd make your decision as to who to rehire once it was your company.
That's correct, Your Honor.
Okay.
Quite candidly, I believe that my motion to dismiss on this basis should have been granted. But our system of justice, although not perfect, I think gives the plaintiff every opportunity to establish a claim. And what the trial court held in that initial hearing on my motion to dismiss was that he had pled a contractual relationship and that he would have an opportunity to prove one. He is unable to do so because no such contractual relationship ever existed between the plaintiff and IPC.
What's really tough about this case, of course, is this issue of whether there did or did not, were or were not contracts. We know this doctor moved from northern Alabama, gave up his entire practice, sold his home, came down here thinking he had a job. Didn't work out. Everybody takes the position that, hey, we didn't have a contract with him, but yet he's being held to a non-compete agreement and a contract. It just has a very unjust, harsh feel about it.
And, Your Honor, I would say two things in response to that. One, it was very clear Dr. Bloom understood that he did not have an employment relationship with IPC. During his deposition, Dr. Bloom admitted that they were asking him to sign that disclosure and authorization form so that they could obtain additional information regarding his background. And he refused to do so unless they guaranteed that they would honor his contract with Synergy. And unless they guaranteed to him that he had a job there, he was not going to sign anything additional. He was not going to further cooperate. He understood at that point that he did not have an employment relationship with IPC.
Is there any evidence in this record that your client did anything to suggest that the non-compete agreement was enforceable by your client against this physician?
Absolutely not. There was no discussions between my client and Dr. Bloom regarding that restrictive covenant. And as an employment lawyer, I think it's an interesting legal issue as to whether IPC could have ever enforced that agreement, but that is not the issue before the court today because IPC never took a single action to enforce the terms.
Are there any allegations in this complaint that you did attempt to that?
No, sir.
All right.
No, Your Honor. And so that is one of the issues in which the plaintiff attempts to distract the court by saying that there was a contractual relationship because they retained the right to enforce that agreement, but they never took any action. And so that issue as to whether they could have taken any action to enforce that agreement is not the issue before the court. The issue before the court is whether that establishes a contractual relationship to hire Dr. Bloom. And that asset purchase agreement specifically spells out the assets that they are acquiring. It did not include those contracts with the healthcare providers. And furthermore, the asset purchase agreement specifically states that they would hire only those qualified healthcare providers listed that met their employment criteria. And that employment criteria was not set forth. There are no restrictions. There are no limitations on that employment criteria. And one of the things that the plaintiff tries to, again, distract the court with and to get around the absence of a contractual relationship is my client became concerned about some of the information that was in his credentialing package. And there's a big issue here that the plaintiff would like you to believe that credentialing is the same thing as an employment application process. It is not. It is very, very different. Credentialing is, do you meet the basic requirements necessary in order to treat patients at a hospital? And that is for a hospital to decide. Employment application is whether you meet the criteria for an employer to employ you as one of their employees. And because of the information that they saw regarding Dr. Bloom in his application process, they wanted to get a further background check on him, but they need his authorization to do that. And that is what he refused to provide. One of the things, sure. In closing, I would say that none of the issues that the plaintiff has raised addresses the issue of the absence of the contractual relationship. Thank you very much.
Okay, thank you. Mr. Dander? Let me ask you, we've been making some arguments on your behalf, but I'm not entirely certain that those arguments were made in your brief to this court. Have you been arguing what the court's been suggesting here?
Yes, well, we argued about the 90 days because 90 days means you get paid for the 90 days. Otherwise, it wouldn't have 90 days. The there was never any discussion about cause, and for cause or not cause, because there was no cause. I mean, and there was something that Mr. Brennan brought up about license. You can terminate it for cause if you don't have a license. It doesn't say in Florida. Actually, it says if it ceases the active practice of medicine. He's never ceased the active practice of medicine. But the thing about IPC, they're saying they didn't discuss the non-compete with Bloom. They wouldn't talk to him. He tried to call. Emails were going back and forth. I want to come and talk to you. He didn't give the disclosure acknowledgement form. He wanted to hand it to them. He wanted to find out about the non-compete. That's all in the records. That's all in his testimony.
Mr. Damodar, we got opposing counsel to make some arguments that were to your client's benefit, so I'm going to give you an opportunity to make an argument to his benefit, or maybe not. You alleged in the complaint, in count 1, which many of our questions have been focusing on, that on or about May 6th, Synergy contracted with your client to perform medical services and agreed to pay for relocation expenses and cost of credentialing, which plaintiff expended in reliance on the contract, and then you refer to the contract. Defendants owe the plaintiff in accordance with the contract. You haven't pleaded anything as far as a failure to compensate your client for wages earned or contractual damages earned for 90 days of providing services.
I didn't do it specifically 90 days because I did for the whole contract, whatever he was entitled to under the contract. Because the contract has more than the 170. We have the representation that's going to be more of $200,000 a year. Actually, everything that the contract provides, I don't know what it actually provides until we got into more discovery. So that's why my complaint's the way it is. I originally filed a complaint, and I know I filed an amended complaint because I never had the IPC asset purchase agreement.
But what I'm concerned about is the way you pleaded it. As I read it, it sounds to me like the damages you were seeking are relocation expenses and costs of credentialing. And the trial judge basically focused on that in granting summary judgment. Said, well, here's why he's not entitled to relocation. Here's why he's not entitled to credentialing expenses. So I guess what I'm concerned about is what put the court on notice that other damages were being sought that were not properly resolvable by summary judgment.
Dr. Bloom's deposition was filed by Dr. Nussbaum. I think I may have filed it too, but he specifically puts his damages in there. He's got the damages for the fraudulent inducement. He didn't sell his home, but he lost it to foreclosure.
My question relates to breach of contract. I want you to set aside, for purposes of this question, any other cause of action. Your client was terminated. Your contention is he was wrongfully terminated, either without notice or with ineffective notice. So did your client in his deposition say, I am entitled to either X number of dollars or I'm entitled to an unknown amount of dollars because I was entitled to 90 days compensation for pursuant to the contract? And don't tell me yes if you don't know.
Before he came to me, he went to another attorney who wrote a demand letter asking for the 90 days. Then he came to me and I filed suit for all damages. You said
in his deposition he outlined his claim for damages. What did he claim?
He claimed for the salary that was owed him. I'd have to look for specific, but I don't remember specifically, but he would claim for the damages. It was addressed, I believe it was addressed, I think the attorney was Gary Siegel, did the demand letter for the 90 days.
Is a demand letter proof of damages?
It's not a proof of damages, you ask for requested damages.
Okay, let's set that aside too. Let's set that aside too.
Okay.
You said that your client proved his claim for damages in his deposition. I mean, essentially, I'm giving you a little extra wording.
He listed his damages, yes.
And did he list in his damages a claim for termination that he was at least entitled to 90 days of compensation based on that annual salary?
Yes.
Okay.
And also I wanted to point out Appendix 5 to my brief has those letters that we discussed on August 5th. The one that my client didn't receive that was sent by certified mail, it says that on May 6th, I'll paraphrase, you executed the physician agreement. Synergy did not execute the physician agreement and has decided to sell substantially all of its assets and deceits providing hospice services. According to this letter, this letter is written to provide you notice that Synergy will not execute the physician agreement nor employ you to provide hospice services. However, please note that the buyer of Synergy Assets Inpatient Consultants of Florida would like to discuss employment with you. So this doesn't say you're terminated. It says we're not going to sign the employment agreement. Then we have affidavit saying that, oh, he was employed since May 6th. You know, after we filed the summary judgment saying that they did not have express orally or written consent to use his name. So then they changed it. He was an employee. Court found that it was implied consent to use his name, which the statute says it has to be expressed. So again, a change in circumstances. The one that went by email to him on the same day, August 5th, talks about, I discussed with you upon our initial conversation the possibility of Synergy being acquired by a larger entity. This has taken a more formal shape. This will serve to confirm that Synergy is being acquired by IPC, the largest and best integrated hospice group in the world. From a practical standpoint, things will not be much different, and assuming you become credentialed as expected, the opportunity exists for you to continue with the new group under their agreement, which in overall respect is superior to that of Synergy.
You've used up your time here, so you need to wrap it up.
All right. The summary judgment should be reversed, and I even put in my brief that, and I still find that there's enough evidence actually to enter summary judgment before the plaintiff. The court never even considered our summary judgment motion. It was encompassed with our motion for sanctions for changing positions with affidavits and depositions, and using affidavits or depositions proved to be false. Thank you.
Okay, thank you. Next case on the docket is Paddock versus Kingsway.